The professional responsibility question from February of 2005 is a challenging and difficult essay question. This is one of the harder questions to appear on any recent administration of the California bar exam. And that makes it a very important and a very useful question for our studies together. Take a look at the call of the question, and you'll see it's obviously basically a PR question. Look at call number 1. Did Anne commit any ethical violation by interviewing Carl? Discuss. Well, that seems fairly simple, but as it turns out, this is really quite a challenging question, and answering it well requires us to do a very thorough, careful job of analysis. It's not an easy question. Next, question 2. What are Anne's ethical obligations with respect to Chief's memo? Discuss. Again, it seems like a fairly straightforward question, and one would think, mistakenly, that it lends itself to an easy, quick answer. It doesn't. And we'll see that, again, we are called on to do some fairly high-level analysis under very strict time pressures. Then turn to call of the question number 3. At trial, how should the court rule on objections by Bob to the admission of Chief's memo on the grounds of attorney-client privilege and hearsay? Discuss. Well, as far as I can tell by looking at this call of the question, it's an obvious evidence crossover. And it turns out that's exactly what it is, by the way. So my initial outline to call of the question 3 is to lead off with relevance, just like I do in all other evidence questions, and then go into the objections. And they give them to us, attorney-client privilege and hearsay. Ordinarily, I would talk about them in the opposite order, but I guess I'll be responsive to the way they do it here, and I will address these issues in the order that the call of the question asks. Then I'll reach a conclusion. So by looking just at the call of the question, we're able to do a thorough job outlining only one of the 3 calls. Now, go to the top of the pattern, and we will see in these 4 short paragraphs some very complicated facts that require us to think on our feet and then do some serious analysis. Look at paragraph 1. Here we are introduced to Anne, the lawyer who is the topic in the first 2 calls of the question. She is plaintiff counsel in a civil rights lawsuit involving employment discrimination alleged by a female police officer against the city police department. Bob, who is referred to in call of the question 3, is defense counsel representing the police department. So we don't really get any issues in the first paragraph, but we do get some background information that is helpful. In paragraph 2, we learn a lot of details about call of the question number 1. We find this plaintiff's counsel interviewing a whistleblower captain within the police department. And I think most of us would look at this and think quickly that there's really no problem with this interview. And that's what I conclude. But to put that intuition into some structured, sensible bit of analysis is a lot harder than it might seem at first. Again, working under time pressure, this is not an easy question to really do justice to within those time constraints. In paragraph 3, we learn facts about the defendant police chief's memo to defense counsel. And this obviously has very high probative value. A plaintiff alleging gender discrimination against Chief and against the police department will benefit from this document. Now, paragraph 4 is where all these issues come to a head. Bob's paralegal accidentally delivers a copy of this explosive memo to counsel for the plaintiff. And now we get the call of the question again. Obviously, defense counsel wants that memo back, and now plaintiff's counsel wants to use that memo in trial because obviously it would make her case. So then we get the call of the question again, and as I think about the call of the question afresh, having looked now at the fact pattern, again, it seems as if the first 2 calls of the question are deceptively simple. Did Anne commit any ethical violation by interviewing Carl? No. What are Anne's ethical obligations with regard to Chief's memo? She's got to return it. It's pretty simple. Okay, how do we turn those quick answers into something that's worth points on the bar exam? We look at call of the question number 3, and we see nothing new. We'll organize it just like the evidence question it is. Turn the page and take a look at the outline of issues that I present. As I organize my thoughts about call of the question number 1, it seems to me that the best way to do it would be to organize around duties. Why? Because we don't really have enough facts to organize around the facts. I suppose it would be possible to do it that way, but organizing in this way makes it possible to find a home for all of the different factual details in a context that is completely grounded in the law. Notice, I think the key fact upon which this analysis turns, it's in Part 1D. Carl is not a named defendant. He's a true whistleblower. His testimony is invaluable to the plaintiff. Now, would it be possible to write a competent answer that reaches the opposite conclusion? Absolutely yes. Now, turn to call of the question number 2, and here I choose to organize this answer around the facts, and I do it chronologically again. One could, I think, organize this around ethical duties, but I find it easier to do it this way. Then I turn to call of the question number 3. I've got nothing new to add to the outline. I treat it as a simple evidence question. Now, please turn to my model answer, and let me direct your attention to a point which I think is one of the more important ones that I can make using this answer as a reference point. Oftentimes, when I work with students, one misconception that they get from what I have to say and from my written work is that the law isn't very important. And it's true that one of the most important points that I make throughout all of my work on bar exam essay writing is that boilerplate is a bad idea. But it's also true that merely reciting the facts is a bad idea also. What one must do to get the highest possible score is first spot the issues, and then, more importantly, I think, connect the facts with line items within the legal analysis. So, look at my answer to Part 1. Did Anne commit any ethical violation by interviewing Carl? Notice that I lead with the facts, and I set the stage for all of the analysis that follows. And this recitation up front is not merely copying the facts. It is an explanation of what happened that leads me to analyze the duty to exercise independent legal judgment, the duty of candor, and the duty of zealousness. Now, does one have to do it this way? Absolutely not. Is the duty to exercise independent legal judgment really a significant issue? I don't think it is, but the fact that Patty requested an interview Carl is something that I want to find a home for, and this is my way of doing that. I turn to the duty of candor, and I think this probably is the most important single issue to answer call of the question number 1. And the content of Part 1B of my answer, the duty of candor, and Part 1D, the analysis about Carl not being a party, these are the 2 key paragraphs in an answer to this part of the question intellectually. The rest of it, I think, is just trying to be as thorough and as analytically complete as possible. Ultimately, I conclude what my snap decision was in the first place, that it makes sense for Anne to conduct this interview and that it was not unethical for her to do so. Now, turning to Anne's ethical obligations with respect to Chief's memo, here, I think the law is so simple. This is such a narrow question that we are being given that I just can't come up with good law to organize this part of my answer. So I fall back on the facts, and I go through them chronologically. I talk about the inadvertent disclosure of the memo, the fact that the memo is work product and protected by the attorney-client privilege, and I point to the fact that defense counsel has immediately demanded the return of this memo. And I conclude that Anne is ethically obligated to return Chief's memo. Would it be possible to write a cogent memo that reaches the opposite conclusion? Sure, but probably it would be wrong. I think this is a clear-cut, correct answer. And perhaps reasonable people can differ, and maybe, once again, this is my bias as a defense lawyer coming out. But I think I'd reach the same conclusion if the parties' identities were reversed. I don't think this is a complicated ethical question. Now, turn to my answer for call of the question number 3 with regard to the admissibility of Chief's memo. And here again, I think this is simple. I think this is absolutely work product, and I think it's a slam dunk for the defense to keep this document out of trial. However, writing 2 sentences is not good enough to get a passing score on any bar exam essay. So notice at each step of this analysis, but obviously more with the objections than with relevance, I find a home for every detail, and I interpret every detail. This is an example of a question which is quite difficult in my mind because they don't really give us very much in terms of organization. We have to identify what's at issue ourselves, and we have to provide some structure to make our answer meaningful within pretty harsh time constraints. So I think this is one of the best constructed professional responsibility essay questions the California Bar ever has administered. And I think it's one of the harder essay questions that you're likely to see in any seminar of this course.